This is Nebraska Farmcast, a production of the Center for Agricultural Profitability from the University of Nebraska-Lincoln's Department of Agricultural Economics. I'm Ryan Evans. The Nebraska Legislature's first session of 2022 is underway, and Legislative Bill 806, introduced by State Senator Bruce Bostelman, would significantly change Nebraska drainage law and bring what some say is a long overdue reform to Nebraska water law. With me to discuss this is Dave Aiken, Extension Water Law and Agricultural Law Specialist here at UNL. Hey, Dave, thanks for joining me again.
Hello, Ryan. Good to be with you.
So what can you tell us about LB 806?
Well, current Nebraska law allows landowners to drain water from their land onto their neighbor's land so long as the upper landowner follows the natural drainage, and so long as all the drainage facilities, any pumps and tile drains or whatever it might be, are all on the upper field. And basically this can be done almost without regard to how much water is dumped onto the lower field, even if the lower field ends up being flooded. And LB 806 would change this.
So the current law sounds like it's a little tough on the lower landowners.
Yeah, it really is. And I have always felt that this provision of the drainage law is the most unfair feature of all of Nebraska water law, and maybe even all of Nebraska agricultural law.
So what would LB 806 do?
Well, it would basically change the law of 180 degrees so that if it were adopted, upper landowners could not do any drainage activities putting water onto their neighbors if that water hurt the neighbors.
Well, you said it, a 180-degree change. That sounds like a pretty big, substantial change from a long-standing law.
Yeah, this law is well over 100 years old, and this change would basically be a revolution. And I think the language of the bill would make it clear to all the relevant parties, including all the lawyers and all the judges involved in these drainage cases, that the upper landowners can't damage the lower landowners, even if they follow all the rules and the water is kept in the natural drainage the way the law is today.
And can you just clarify what you mean by upper and lower landowners? What's meant in the bill's language?
Sure. Basically, as we all know, water runs downhill, and so upper landowner is the one that is doing the drainage, and the water that's being discharged from the upper landowner then flows down to the lower landowner, and they're the ones that end up with the extra water that they don't want.
And you also mentioned lawyers and judges. That's
right. This is a legislative proposed redefinition of basically property rights. So there's no administrative agencies involved, natural resource districts aren't involved, Department of Natural Resources or Department of Environment and Energy, none of the state agencies are involved. It's just the neighbors. But it changes the legal rules for these disputes. So the way it would work out, if I'm the upper landowner and I put extra water onto you through my drainage activity, if you and I couldn't work something out, I'm not taking your phone calls or whatever, you go see your lawyer and says, Aiken's doing this to me, do I have to put up with it? And your lawyer says, no, they changed the law in 2022, so you don't have to put up with it anymore. So I'll write Aiken a letter, and maybe that'll get him, where he needs to be. So I get the letter from your lawyer, I take it to my lawyer, and my lawyer looks into it a little bit and says, well, yeah, they changed the law. And so you can't, even though before this law was changed, you could do it and you'd be in the clear. Now you're not in the clear. And if you're putting too much water on the neighbor, you're in violation of the law. So if they can make a good case in terms of the water that you put onto them is too much, we're going to lose if this thing goes to court. So this would be a big that's kind of how it would work out. It would still be a private type of deal between neighbors and potentially between the neighbors and the lawyers if it ends up in court. But hopefully these things would be worked out without having to go to court.
And do you anticipate a lot of controversy around this proposed change?
Well, it's kind of hard to say. I mean, this is not a well understood feature of Nebraska water law. And when they had the hearing on the bill at the end of January, nobody testified against it. Nobody even testified neutral. Everybody testified in favor of it. So we'll see what happens. If there end up being amendments proposed and stuff like that, that would be, we're just going to have to watch and see what happens. But right up to now, it looks like it's got a good chance of being adopted this year.
Great. Well, definitely something to keep an eye on. And Dave, we appreciate your efforts to tell us about this and bring attention to it. And if listeners want to take a look at the transcript from this conversation, we'll post that on our Center for Ag Profitability website at cap.unl.edu, where you can find a host of other great material from Dave and our other faculty here at the center. So again, Dave Aiken, Extension Water Law and Agricultural Law Specialist here at UNL. Thanks very much for your time and the information today.
Thank you, Ryan. We'll talk again soon.
All right. Nebraska Farmcast is a production of the Center for Agricultural Profitability at the University of Nebraska-Lincoln. For the latest research-based information and education resources to manage your farm or ranch operation, visit our website at cap.unl.edu. That's cap.unl.edu.